infringes any of the fundamental rights that the citizens may have.
Well, if due process is interfered with, surely
They have not shown anything to say that there is any due process which they are entitled to under the existing scheme or the scheme as it stood prior to this act.
We made questions. You can continue. I think we have our own views and opinions. Aap chale aage.
Now,
you have to persuade us, not we have to persuade you.
Just one question I was just thinking about it. Suppose a provincial assembly or even the parliament tomorrow makes a law saying after an appeal has been pressed under Article 185, another appeal would be available to the litigant before a larger bench. Would that law stand?
I would rather consider these.
Competence ki baat kar raha hu.
Let's consider what law did. Maybe tomorrow that very matter comes before us.
So the question is.
A second appeal. My Lord's question is whether the second appeal would be provided.
Not at all. I am questioning the competence. The appeal in the Supreme Court under 185 is provided by the Constitution. Can another appeal, which is not specifically provided in the Constitution, be provided by ordinary legislation? The example I gave you was an extreme example.
Right,
the first question is, can by ordinary legislation an appeal be provided where the Constitution specifically does not against orders passed by the Supreme Court?
I will add to this question. Is there any provision in the Constitution preventing
जो वो टेस्ट है कि जी वो आइटम 55 का कि जी वो हमने तो enlarge किया, पहले एक अपील थी, अब हमने दूसरी कर दी है, तो इसलिए ये हमारी competence में है. Would that argument stand?
Noted, my lord.
आप बाद में जवाब दे दें, आगे बढ़ते हैं.
ऐड कर रहा हूँ उसमें दूसरी तरीके से. Is there any provision in the Constitution preventing the Parliament from doing so?
Noted, my lord. Now, my lord, if my lord may kindly turn to Article 191. Let's go to Article 191. It has been read out. I'll just read the first part of it, where it says, subject to the Constitution and the law.
Mr. Attorney General, please you read just the preamble of this act and section 3.
Yes. Yes, my lord, it has been read out.
Talks about Article 10A.
Article?
10A.
Yes, it does.
Specifically. And Article 4, Article 25.
My lord.
And subsequently in section 3, specifically talks about 184.3.
My lord.
How this can be
proceeded
under Article 199 when specifically it is challenging the mandate of the Supreme Court as per section 3 of this act.
My lord.
How that can be moved before the Supreme High Court under Article 199 of the Constitution?
My lord, I noted. My lord, now the question that has come before your lordship is whether this Act, 2023 Act, is covered under the definition of law, howsoever expansive definition, howsoever expansively the term law is defined. My lord, Article 260 has two definitions. One is of an Act of Parliament and the other is of a federal law. Here we are dealing with the federal law. Article 260 defines a federal law. It says...
You say over here law includes statute law.
Yes. Yes. In my respectful submission, law can only have one meaning as far as this provision is concerned. But even if it is given an expansive meaning, this act would surely be covered under the definition of law.
If it's to be covered, then why didn't the Constitution say by an act of Why did it use the word law? These words are not interchangeable. They are used in a very specific sense in different articles, and so you have to, the interpretation has to be given to the word law, and not to just say, just because law includes legislation, so here it will be legislation alone. Law has a meaning, and if the Constitution wanted to say it just by an Parliament, it would have used those words.
Your Ladyship, provisions from where the Parliament draws its
Why did you
legislative...
look at 75(3)?
जी 75(3) and 141 and 142 as well.
पढ़ लेते हैं जरा, उसमें दोनों लफ्ज इस्तेमाल हो गए.
When the President has assented or is deemed to have assented to a bill, it shall become law and be called an act of Majlis-e-Shura.
So it is happens. What it is, the name of the thing is, you are a man. Your name is Mansoor Rahman. I would read it like that.
And the definition of federal law under Article 260 is, federal law means a law made by or under the authority of Majlis-e-Shura Parliament. Now, if we turn to Article 8.2, for the sake of this submission, where any law which is inconsistent with fundamental rights is void, Article 8.2 says, the state shall not make any law. Now, the state is not just the Parliament, the state is the province, the governments and the assemblies and any authority which has the power or is authorized by law to impose any tax or cess.
आप फरमा रहे हैं कि law, and you refer to the definition of federal law. You don't say federal law, it says...
It does not. What I'm saying is...
I have a question for you. Suppose Judicial Assembly under Article 191 law बना देती है, बना सकती है?
Oh, 2000 के अंदर, 2000 Supreme Court deals with that question. Yes, they cannot. The answer, because the power with respect to legislation with respect to regulating the court's jurisdictions or powers flows from entry 55, so 191 or 175(2) for that matter.
Respect, I draw your attention to entry 50.
Relates to the federation also. Yes.
Ji. Kindly read it.
Ji. Matters which under the Constitution are within the legislative competence of Parliament or relate to the federation.
So therefore it seems to me, and I put it to you as a question, that actually entry 55 has nothing to do with Article 191. The power that is specifically conferred on Parliament to make statute law, and in terms of Article 191, is it is a specific grant, it relates to a specific entry 58. So I would put it to you as a question that 51 has no relevance for the present issue.
Entry
55. Has no relevance. This is a matter between, and insofar as law is concerned, statute law, Act of Parliament, the connection is 191 and entry 58. I would say to you, entry 55 has got nothing to do with it. What would you say to that? Keep it in mind and move on.
Well, now, my lord, if my lords may kindly turn to Article 141. This is with respect to reference to the use of term law in Article 191.
Should be read with Article 260.
260.
Act of Parliament. So here is the word is law, so you can
yes.
read together.
And 141 and 142 also is in continuum, my lord. 141. Subject to the Constitution, Parliament may make laws, including laws having extraterritorial operation for the whole or any part of Pakistan, and a provincial assembly may make laws for the province or any part thereof. Now, saying that the term law used in 191 can possibly exclude this act would be contrary to the entire structure of this constitution as I understand it.
Let me take you to the next point, which is, would it be confined only to an act of Parliament, or could it also include case law? Because we know that judge-made law in a common law jurisdiction like ours is absolutely law. So, is it your case that law as used in 191, whereas in review jurisdiction it says Act of Parliament, talking about jurisdictions, powers of the Supreme Court. So when they speak of law, use law in 191, are they confining it to statute law, Act of Parliament, or is it both statute law and case law?
And I'll just, it's the same question, but just saying it differently. Your argument is that the word law includes this statute, this Act of Parliament.
No, sorry. Let me
The exclusion of anything else, we would read the Act of Parliament in the word law.
Yes.
So my question is,
Only Act of Parliament.
all right. So my question is, if that was the intent of the framers of the Constitution, then why use the word Act of Parliament in some provisions, in some articles, and use law elsewhere? If the idea was that wherever we want, we could just read it, a law meaning just an Act of Parliament, and wherever we want, we can read law and everything along with an Act of Parliament, it would again be left to us to decide where we want to read, how we want to read it. But the Constitution has given specific words to mean specific things.
भाई अब एक चीज जो आप देख रहे हैं ना, आप पता नहीं, I don't know. What about an ordinance? Ordinance is a law, but not an act of Parliament. As simple as that. The president can promulgate ordinance. It is still a law.
It would be covered under the definition of an act.
So,
See, 267
Learned Attorney General.
मतलब आप आगे बढ़ें, please look at 267.
Learned Attorney General.
जो statute है या जो act of parliament है वो 260 में defined है, ठीक है
जी
267(7) देखें, उसमें law क्या है? Ordinance, rules, bylaws, regulations, letters patent constituting a high court.
This is existing laws.
Any yes,
With given
but
continuation.
law.
Yeah.
And any other legal instrument having the force of law. Now, surely, judge-made law is law.
Learned Counsel.
with the
Learned-
greatest of respect, if it's observations coming from the bench, I have severe reservations for
Learned,
this.
I'll respond.
Because it's not a question, it's a statement.
No,
I want to disassociate myself from this
My lord,
statement.
I would
Just
I'll
But
address
there is no such thing as
2020
judge-made law.
306.
Learned Attorney General.
Mr. Attorney General, kindly read clause 2 of Article 260.
Learned Attorney General.
पहले जरा वो clause 2 of Article 260 तो पढ़िए. Clause 2 of Article 260.
जी. Yes.
Clause 2, Article 260.
जी, an ordinance is included, yes.
Kindly पढ़ लें.
In the Constitution, Act of Parliament or federal law or Act of Provincial Assembly shall include an ordinance promulgated. Yes.
Yeah,
That
Learned Attorney General. The Parliament and its Supreme is because of its representative character. Now, if there is a law, an act of the Majlis-e-Shura, and that is in conflict with a judgment of even a full court, whether that act of the Parliament will prevail or the judgment of this court.
my lord.
It will be the act of the Parliament.
And if there is a judgment which has been rendered on the basis of, and this is where the principle of legislative overrule goes from, that if there is a judgment expounding a certain provision of a statute or the rules, that judgment ruled unless the basis or the foundation on which that judgment came about is altered or removed, which is to say, if the law, underlying law is amended, then the effect of that judgment goes away. And that is where, even if, for the sake of argument, the term law includes a judgment, if the underlying, if the rules which were expounded by your lordship in that judgment,
First of all, I didn't say judgment, I said case law. Judge-made law is different from judgment.
Case
That
law.
is precedent.
So Learned Counsel.
And also, जो आप जो अभी बात कर रहे हैं, extrapolating from that, is the rule surely कि an interpretation of the Constitution or the establishment of a rule of constitutional law by the Supreme Court surely cannot be affected by Act of Parliament. It can only be if the Constitution is amended or the court itself changes its view. Classic example, right of abortion. Added to the Constitution, Roe versus Wade by the US Supreme Court. Taken away as egregiously wrong by in Dobbs versus some other 2022. I think surely that is settled constitutional law.
My lord,
आप जरा please, if you don't
if I may,
mind,
I have to take your lordship to
आप
now
जरा please
order.
proceed
Proceedings we
further.
have
I mean,
discussed
we will
about.
write a judgment, whatever we want to write.
Now, my lord, I will,
Mr. Reggie,
my learned colleague
thing-
will be recording the
one thing-
questions, noting down the.
I understand this. This is not my
Mr. Amir
statement.
Rahman knows shorthand.
This is not my statement, this is my understanding. Act of Parliament can be considered as law as well. But every law cannot be considered as act of the Parliament. जैसे कि आप मिसाल लेते हैं, landlord can be landlord, but owner can be treated as owner as well as landlord. तो इस तरीके से ये जो legislation है, तो Parliament करती है, उसको आप law भी कह सकते हैं, act of Parliament भी कह सकते हैं, लेकिन जो जजमेंट या केस लॉज से आते हैं या कस्टमरी लॉ होते हैं, उसको आप एक्ट ऑफ पार्लियामेंट नहीं कह सकते, तो इसलिए उसको कन्फाइन किया गया, लॉ किया गया।
कह भी नहीं सकते, my lord, और दूसरा एक और just let's look at it from another aspect. Now, 1980 is when these rules were made. And when these rules were made, if I draw your attention to Order 11, Order 11 को जरा
अगर हम बहुत ही pedantic approach ले
Order
लें,
11, my lord.
ये pedantic approach ले लें, ये किसने बनाए? ये किसने बनाए?
Supreme Court ने
कब?
1980.
Supreme Court क्या होती है? नहीं, hang on. Now, if you go into that approach, Supreme Court क्या होती है? बताइए.
All the Chief Justice and the judges.
Sitting at home? No way. No, but if you're going to go that route, then you can even say these are what is they say Supreme Court can make, not administrative meeting of the judges of the Supreme Court. Where does the Constitution provide for an administrative meeting of the judges of the court? So we don't want to just destroy the entire system of governance. So did we sit in a court of law? Did we pass a judgment? How did these rules get enacted? Did people have a say in the matter? Or 10, 15, 17 people, then all gentlemen got together in a closed room and say, is the concept of an administrative thing. That administrative concept itself is created by the rules. So it cannot supplant the Constitution itself. It says the Supreme Court. It's very clear. Now, I am not really understanding. I am only concerned with one and only one thing. What have we taken away from Khwaja Sahab, his client, or any citizen of Pakistan? What have we taken away? What have you taken away? If you've taken away something, we will strike it down. I mean, I don't know why we are having this academic discussion. I really don't understand the point.
My lord, if I may.
Ji.
Now, there is this provision under this law, and Section 7, for example, application for fixation of urgent matters. Do we not know that there are people who died in prisons, condemned to death, before their appeals came up for hearing?
This is our domestic affair.
No, with great respect, my lord, it is not.
It is.
Absolutely not, my lord, with great respect. This is the right of the citizen, litigants ka right hai.
From the
Learned
executive,
Attorney
it is domestic affair.
My lord, with great respect, it is
We can
not.
resolve this.
It can't possibly be.
Learned Attorney General, what if the Chief Justice refuses to call a meeting of the full court and refuses the full court to amend the rules? Should the Parliament not intervene in the interest of the litigants? That is exactly what has happened.
And here, if my lords may kindly turn to Order 11 of the Supreme Court rules. Order 11 of the Supreme Court rules. I'm just going to take this point forward. Order 11 of the Supreme Court rules. It begins by saying, save as otherwise provided by law. The full court, going by, let's say,
एक मैं आपको इसमें तसादुम दिखा दूं अब मौजूदा रूल्स में जो आइन से तसादुम रखती है, ठीक है? अपील इज अ राइट, सिविल पिटिशन फॉर लीव टू अपील इज नॉट अ राइट. फॉर एन अपील द रूल्स प्रोवाइड 30 days, which is a right. For a civil petition for leave to appeal, you get lots of time, 60 days. I would say it violates the very concept of the Constitution. Maybe it's a mistake, but the other question would be, can these rules be challenged? I think they can be challenged. If they had a supra-constitutional effect, they can't be challenged. Suppose tomorrow I refuse to fix any bench. What will compel me? At the moment there is stay order of reason, I said, nahin, hum chutti pe jaate hain, hum court hi nahi lagate hain. What will you do? Move a reference against me, that's about all. You can't compel me under any law to do that. So, the object is, there has been a problem, there has been successive addition of cases, we are completely closing our eyes to it. हम 2019 में full court meeting हुई थी, वो भी हम नहीं कॉल कर सकते, वो भी इख्तियार चीफ जस्टिस का है। 2019 से 4 साल गुजर गए हैं, क्यों नहीं मीटिंग कॉल हो रही है? 2019 से उस जमाने में 40,000 केसेस थे, अब उसमें ऐड हो गए 27,000। हमारी मर्जी, हमारा डोमेस्टिक अफेयर है? नहीं, हमारा डोमेस्टिक अफेयर है, पर हम तनख्वाह नहीं लें स्टेट से। हम टैक्स पेयर हमें पैसे देता है, हमें एक काम के लिए पैसे देता है, केस का फैसला करो, ये हमारा काम है और कोई काम नहीं है, बाकी सारे हमारे पेरिफेरल काम है। तो ये आप इतने आप उस मेन पॉइंट पे आप नहीं रह रहे हैं, आप भी खिसक रहे हैं उधर, वो भी मेन पॉइंट पे नहीं आ रहे हैं।
My lord, I just
ये जो आप पढ़ रहे थे
rephrase
कॉन्स्टिट्यूशन ऑफ बेंचेस का,
जी,
इसको पढ़े ना, ये सेव एज अदरवाइज प्रोवाइडेड बाय लॉ।
जी, सो
तब तो कोई लॉ था नहीं
जी, उस वक्त नहीं था। रिकग्निशन थी कि लॉ प्रोवाइड कर सकता है कुछ,
नहीं, आपसे ये अभी देखिए,
उस वक्त लॉ नहीं था।
अब ये लॉ, क्या ये आपके ख्याल में ये जो 1980 के रूल्स हैं, ये लॉ है?
My lord, these are
आपसे सिंपल, आर द 1980 रूल्स लॉ, कम विद इन द पर्व्यू ऑफ लॉ?
191 की डेफिनेशन क्या आप
आर्टिकल 191?
नो सर,
नो,
दीज आर द रूल्स।
these are the rules. The language says subject to the and the law, the Supreme Court will make rules.
What is the purpose of mentioning save as otherwise provided by law?
Yes, this is the recognition of what Article 191 provided. Now, at that time, there was no statute or an act of parliament which provided for anything, but the full court of this court left it open.
Now the law has been promulgated, and this covers under this provision.
Yes, not just this provision, it is covered under 191. This only recognizes what 191 already.
Mr. Attorney General, then you are excluding all those laws which are made under the delegated powers. You are excluding all those laws which are made under the delegation of the power by the government or the parliament. Delegated legislation.
In what context, my lord?
In the context of definition of law. There are two primary law and the delegated law. And delegated law includes the rules.
No, we are only looking at the language of 191. We are looking at the language of 199, and we are trying to understand what is the term or what is the scope of term law as provided under 191 is.
Yes.
Now, I had taken your lordship through how this provision or the pari materia provision had historically progressed, where in addition to Parliament there was a executive as well. That role was taken away, that role was eliminated, but the role of Parliament remained. And, my lords, Article 67, which provides for the regulation of the rules of procedure of the houses, there is no such
You have not
language.
You have not argued on Article 142, because this is the distribution of legislative power.
Yes.
And Majlis-e-Shura Parliament shall have exclusive powers to make laws
With respect
to any matter in the federal legislative list.
Yes.
And if we go through Article 50, the legislative list of item 57, it is also related to
58.
58. उसके साथ 55, sorry, 55
yes,
jurisdiction
it is,
and
yes.
power of all courts.
So insofar as Section 5 is concerned, it is entry 55. With respect to other provisions, it is Article 191 read with entry 58.
Article 50,
Why
sorry, item
Why is
58.
it not coming under 55? It says enlargement of the jurisdiction of
It
the
does.
Supreme
That's
Court
what I said, sir.
and the conferring up thereon of supplemental powers. So it
what
has
I
given
submitted,
us
sir.
more powers. I have committed a mistake. I've given you an exact example of a Himalayan mistake committed by this court, the recording judge. 6.5 billion, isn't that a big enough mistake for us to understand?
That's exactly what I've submitted. Section 5 is covered under entry
So
55.
you are trying to resolve that. Why? I don't know. I mean, they don't argue the case. I don't know why we're not proceeding. We love quoting American presidents. Why don't we quote the American president, which the Supreme Court of America says 20 minutes and nothing more?
My lord.
Now, you are not, please don't take questions. You just hear them, write them down, whatever.
Now, my lord, I just stick to the mission that I had made in the beginning. Mr. Amir Rahman is the person who is recording the question.
Learned Attorney General.
अब आप देखिए, हम आज से सुबह से कोई 150 केसेस की एडिशन हो गई होगी because of this case. We can hear this case for the next month. No other work will happen in the Supreme Court. If you want the system to collapse, please proceed. Take your time. We won't interrupt. ख्वाजा साहब नाराज हो कहते हैं, अब आप नाराज हो जाएंगे, मुझे बोलने दे रहे हैं, पॉइंट्स ले, हम नोट करेंगे, हम आपको सुनने के लिए बैठे हैं, आपने इतनी मोटी चीजें दी, हम पढ़ लेंगे इनको.
Now I just quickly rush through my submissions and
my question that in order 11, the use of the word law or the term law, you think it carries the same meaning as in Article 191?
Yes.
Thank you.
Now, my lord, if leaving this act out of Article 191 would render part of Article 191 redundant where it says subject to law. And redundancy cannot be attributed lightly to a statute, let alone a constitutional provision. The judgments are in the paper book. My lord, there was another submission which was made with regards to field being occupied, which is to say that since the rules had been made, therefore the field stood occupied and therefore a law cannot be made. Now, that principle also does not apply because that principle is only applicable where the powers are coextensive or coterminous. Here, the Constitution specifically says that the rules shall be subject to the Constitution and the law. It can't be. So, therefore, the principle of the doctrine of occupied field does not get attracted here. Now, my lord, if I may take your lordships to the individual provisions of the statute before I conclude my submissions. Section 2, my lord. Section 2, as I've already submitted, it endeavors to create more transparency, where the power has been, which was under the rules vested in the Chief Justice, has now been
Call it a sharing of the burden.
Sharing of
it's
the
a
burden.
Huge burden.
Yes.
Why think of it negatively? Think of it positively.
My lord,
I don't want this burden. I want to share it with my colleagues. So what?
Fantastic, my lord. That ends the matter as far as
No,
Section 2
I'm
is
not
concerned.
talking about
Absolutely.
myself.
Absolutely. Absolutely. And because what it does is...
If I don't trust them, that's the only other way. I can't trust them.
It is in this time
trust
when
them 100%.
we want the justice system to be more efficient. It actually helps. There are more minds sitting together trying to work out how to make things more efficient and transparent in order to aid the litigants who come before your lordships, and if I may say so, the primary duty and obligation of this court is under Article 185, exercising appellate jurisdiction. 184.3 is rare cases which come before you under 184.3. It is actually the appellate jurisdiction of this court which this court is duty bound to exercise. So anything and everything which advances that objective, that constitutional objective, must be supported, must be upheld. There is no fundamental right which gets offended or violated by advancing this objective. And Section 2 endeavors to do as much.
So if that was the objective, the law would again be changed if at some stage the government or the parliament decides that no, 3 judges are not enough, let's do it by ballot. So you would amend the law accordingly?
My lord, if I may.
Or let's do it, why 3 judges, why not all 17 sitting and deciding which cases go where?
My lord, if I may respond to this.
Yes, sure.
My lord, if the pendency is down to 20,000, absolutely there would be no occasion. But if it goes to 75,000, there might be.
Why not 10?
Zero.
But
this is what is being sought to be addressed.
You will attend to a matter on that thing. I don't think parliamentarians, we should disparage parliament all the time. If the situation is that there's no pendency, maybe they would have not come up with this thing. Maybe if the damage caused by various was not done, they would have not come up with this thing. So parliament doesn't operate in a vacuum. It hears, the government is part of it, opposition is part of it, all these people are part of it. They think and they produce something. Maybe not in the most perfect of things, but we have to, each legislation must be supported unless it's clear-cut violation of the ultra-vires of constitution, fundamental rights in 184.3. Otherwise, it can be ultra-vires of constitution 199.
Simple. And my lord, the power remains vested in this court.
But Mr. Attorney General, suppose there is a parliament that is elected in the next general election. On your theory, would that parliament not have the power to repeal this law?
Of course.
Oh, you see, you are saying this is a law
If
affecting
it repeals it, yes.
Is that this is a law affecting having such a salutary effect. It is having this, that, and the other. So someone can say, "जी पार्लियामेंट का तो पावर ही नहीं है, तो ये लॉ को रिपील कर दें." या फर्ज करें अगली पार्लियामेंट आती है, वो सेक्शन 2 को फारिग कर देती है, वो कहती है जी चीफ जस्टिस का पावर है, वो दैट्स गुड इनफ।
My lord,
सकती है, आपसे पूछ रहा हूँ।
जी जी।
देखिए अवान साहब मैं देखें प्लीज, मैं उनको भी रोका था और मैं आपको भी रोकूंगा। मैं कंजूस पे नहीं जाऊंगा, मैं रियलिटी पे जाऊंगा। ये कानून आ गया, अब अगली दफा कोई केस ले आएगा हम वो वाला भी देख लेंगे। मैं ओपिनियंस कभी नहीं दूंगा। आप हमारे या तो एडवाइजरी जुरिसडिक्शन इस्तेमाल कीजिए, हम ऐसे आपको ओपिनियंस नहीं देंगे। आपका काम है अपनी सरकार, अपनी गवर्नमेंट को ओपिनियन देना, हमारा काम है उसको उसकी कॉन्स्टिट्यूशनलिटी वैलिडिटी आप देखें, खत्म। हम आपके ऊपर मफरूजे नहीं डालना चाहते हैं कि क्या होगा। भाई हमें क्या पता क्या होगा, जब आएगा हम देख लेंगे। बहुत सारी चीजें आप कर लें प्लीज इस कानून पे और आगे बढ़ा लें बात को, क्योंकि हम देखिए कोर्ट आप समझ नहीं रहे हैं इसकी अहमियत। हम लोग बैठ के इधर एक कंडीशन गवर्नमेंट में बैठ रहे हैं, लोग कोई जेल में मर रहा है, किसी का केस है, मेरी तो मुझे तकलीफ हो रही है। सुबह से 57,000 है, अब हम छोड़ के जाएंगे 150 और बढ़ जाएंगे, कल 150 और बढ़, आप चला लें 1 महीना केस, हमें क्या फर्क पड़ता है। फर्क इसलिए पड़ता है क्योंकि हम तनख्वाह ले रहे हैं इस गरीब अवाम से एक काम करने के लिए कि उनके केसेस का फैसला कर लें, खत्म। ये बहुत अच्छी डिबेट है, जाके हाई कोर्ट में कर लें चैलेंज, वो आ जाएगा जजमेंट नंबर 94 में, हम बड़े पूरे पावर्स के साथ बैठ के इसको देख लेंगे। आपको पता है आज बेंच बनाने का क्या इशू था, इसके बावजूद के स्टे चल रहा है। मैंने अपने 2 सीनियर कलीग से पूछा कि मैं ये करने जा रहा हूँ, 2 स्टे चल रहा है। अलग बात है आइन कानून पर स्टे चल रहा है, फिर भी कि बात को आगे बढ़ा के किसी खत्म कर लेना, सराह लें इस कानून को, ये तर्क कर दें, मगर आप अपने दलाइल दें, हम उसका सुन लेंगे और फैसला कर लेंगे। कोई इख्तिलाफ करेगा, कोई नहीं करेगा, उनकी मर्जी है। हमें आपको परसुएट करने की कोई जरूरत नहीं, आप हमें परसुएट कर लीजिए और सवाल का जवाब नहीं देना चाहते मत दीजिए, हम आपके खिलाफ कर लेंगे फैसला।
My lord, my learned friend is questions.
No, sorry. I'm not indulging in conjectures.
My lord,
I'm asking you a question in order to understand the principles that you are saying and arguing and submitting before the court.
my lord,
I'm not engaging in theoretical argument.
my lord.
I'm trying to understand the basis on which you are defending the
My lord,
constitutionality of this law.
आपका सवाल।
So therefore my question stands. Tomorrow if Parliament were to make this a law and say, let it go back to the Chief Justice in his sole capacity, would that is within Parliament's competence?
My lord, if that is so,
Learned
and if
Attorney
it so
General.
happens,
Question.
Yes,
This is
Learned
not
Attorney
conjecture.
General.
This is to
Learned
establish the
Attorney
principle.
General.
You accept
Learned
that?
Attorney
absolutely,
General.
my lord, absolutely.
Learned
It is
Attorney
in Parliament's competence, and if I may say
I'm
so, my
sorry,
lord,
you
my
have-
lord,
you
I have,
provided assistance.
I
Thank you.
have,
Your
as
answer is
Attorney General.
absolutely.
Ji, absolutely,
Yes.
yes.
Mr. AG, to your right.
Ji.
Section 2 it provided that the bench, constitution of the bench. Suppose bench is constituted. Who will assign the cases to the benches? Still this power has not been given in this act. Again, there will
My
be...
lord, the committee determine its procedure, and then it, with regards to how the meetings are to be, the committee itself.
Who will assign the cases that this case will be fixed before this bench? And one thing more, if 2 members, senior members comes to the conclusion, say tomorrow the Chief Justice will sit in Quetta Registry for 1 month, for 6 months, or for 1 year. Is it possible?
My lord,
What would we do if this situation occurs?
My lord, the committee has to, under subsection 2, after the commencement of this act, the committee had to hold its first meeting for the purposes of determining its procedure, which would have included when and how the meetings were to be held, and the constitution of benches, etc. But that never happened because the law was suspended, or well, the bill was suspended before it became an act, which was also, if I may say so with regret, was a first. My lord, this is exactly what under subsection 2 the committee is to do as the first
We will regulate through rules. They will regulate this act through rules. We
My
will
lord,
clarify it in
Ji,
rules.
the committee will determine its procedure, much the way the Supreme Judicial Council's procedure has also been made. It's not necessarily, I don't know what their relevance, what their status is an SRO, as a rule, or whatever they call it, but the committee can determine its procedure. It will be a procedure of the committee for the purpose of its functioning. Now, Section 3, my lord. Section 3 is exercise of original jurisdiction by the Supreme Court. Now, there was a question which was raised and which was asked when the petitioners were arguing that the committee is to first see whether the matter is, it has to come before the committee to determine if there is a question of public importance with reference to enforcement of fundamental rights, and if the committee thinks so, only then it will constitute a bench. And there was a question raised from the bench that would this not be an administrative power controlling a judicial function? And my response to that, my lords, is that if it is determined, it is held that it is an administrative function and it cannot be performed in a manner to control judicial powers, then my lords would surely come to the conclusion that this court will never exercise suo motu powers either, because while exercising suo motu powers, it is either previously it was the Chief Justice who first determined whether the matter was of public importance and relatable to enforcement of fundamental and then constitute a bench. This is this tension which my lord had also while authoring judgment, rendering judgment.
This doesn't answer the question whether the threshold of 184.3 is to be decided by the committee, as this law suggests, or whether it is the function of the court, whether it's a judicial power. That's the fundamental question, that is this not a judicial power? Because there is a threshold, you say so yourself that there's a threshold. So how can a committee be deciding it? And again, it goes to the fact that if the committee decides that this doesn't meet the threshold, then the person that has filed the petition, they can't challenge that decision?
My question is,
there's a distinction between what is filed
General.
under 184
Learned
and suo
Attorney
motu, and
General,
that's why, my lord.
my question is, if the Chief Justice, just one person, as a master of the roster, could decide whether to take a suo motu or not, why not a committee?
Yes, and that is why my response was that
further
if
providing guarantees, and my only question is, are we not accountable to the litigants?
absolutely.
The Parliament is the representative of the litigants.
So
If they want to change our procedure because they are not satisfied with our internal or institutional independence, that's their prerogative.
And
We are
if I
there
may,
to serve the litigants.
and if I may, my lord,
Normally, you see, the cases would be marked by the Chief Justice, even if it's a 184.3. So I think the question of judicial power is secondary. First comes the constitution of the bench, and then judicial power is going to be exercised. Here we're talking about the constitution of the bench. It doesn't impair any judicial power. The question is, earlier the Chief Justice would mark the case to somebody. He would certainly mark it. I mean, I as a judge would not hear any case unless it's marked to me. And then all it says is that instead of the Chief Justice, the committee marks
Section
it. So
3,
judicial
my
power
lord.
is not in any way impeded, because judicial power comes after the bench. is
Section
marked.
3, Section
No, you
3
see,
talks
Section
about
3
invoking of jurisdiction, and that is
Section
what I was
3
addressing.
specifically states that the committee would examine. Yeah, देखिए, the word
Ji,
used
ji.
is
And that's what I was
examine.
addressing.
After, for examination, if the committee is of the view that a question of public.
Anyway, this is exactly
So
what
it's
the
a
Chief
judicial
Justice-
power.
Yes, yes, yes. So मैं
So
यही
how
कह रहा
can
हूँ.
the committee on the administrative side exercise judicial power?
मैं यही आपको कह रहा हूँ कि if you are minded to hold कि ये जो overlap हो गया है कि administrative function और judicial function को control कर रहा है, you would have to inevitably hold that going forward there will never be a suo motu exercise of powers, because that's exactly what the Chief Justice to do. They will first examine it and then constitute a bench, और यही वो tension थी जो आप paragraph 53
Please take
54
one
में आपने
question
कहा
from
था.
this side, AG sir.
Oh, sorry.
The article 184 begins with the word Supreme Court. What does that mean? Supreme Court means all the judges or only the Chief Justice?
It's what Article 176, your ladyship, says is the Chief Justice and the
184
judges of the Supreme Court.
184 I'm talking
जी जी,
about.
तो 184 में जो Supreme Court है, Supreme Court could जो है वो 176 से फ्लो करेगी।
जी जी।
176 में सुप्रीम कोर्ट का मतलब है चीफ जस्टिस एंड ऑल द जजेस।
All the judges.
No single person
Yes.
is the Supreme Court. It's all of you who are the Supreme Court. So while exercising jurisdiction, अब ये हो सकता है कि आप ये कहें कि नहीं ये सेक्शन 3 जो है ये इस तरह से नहीं होगा, इसको हम रीड डाउन करेंगे और कोई भी एक्सरसाइज सारी कोर्ट बैठेगी और वो पहले देखेंगे कि ये थ्रेशोल्ड मीट होता है या नहीं होता है, and then
You mean to say that
by committee that could be
Mr. Attorney General, the committee is constituted of 3 members to see whether the case do fall within the ambit of 184(3) or not. The litigant would be invited to argue, or that could be only seen by the members of the committee themselves. If 2 out of 3 comes to the conclusion that it is not a case fit for to proceed with Article 184(3), would it not be defiance of right of audience and the Article 10A and all other due process?
in continuation, and what remedy would be available to him, because this is an administrative order, they cannot be challenged in appeal except the chamber appeal under the rules.
Mr. Attorney General, Section 3 is not actually saying that he's going to dismiss the petition at the administrative side. It's simply saying we look at the petition as the Chief Justice looks at the petition. He looks at it, it says a 184(3) petition, he marks it to a bench. It is not saying there is no consequence. Suppose he thinks there is no question, he'll mark it to some other bench. It doesn't say he'll dismiss the petition as to give a hearing to anybody. This is just to look at the
My lord, ये जो threshold है administrative side पे day in day out basis पे हमें cross करना पड़ता है litigants on this side. जहाँ पे objection आ जाते हैं registrar के कि जी ये meet नहीं.
I know what's been happening. Number of 184(3) petitions have come up that the office has put objections.
Yes.
Not the judge, the office.
Yes.
जी one very low.
बिल्कुल.
ठीक है उन्होंने objection लगा दी, not does not come within a
उसके chamber appeal में जाना पड़ता है.
They've come to me, some of them absolutely ridiculous kind of petitions. They're dismissed in my chamber against an appeal is filed. The fact that you don't make available 184(3) does not mean you can't file a civil suit, does not mean you can't file an FIR, does not mean you can't go to 199, does not mean any other remedy. So this is done every day, we do it. Not 3 judges, 1 assistant registrar in the branch office is not maintainable, उसके खिलाफ अपील आती है. वो कितने लोग सुनते हैं? 1 जज. उसके खिलाफ की अपील है? कुछ भी नहीं है. End of story. ठीक है. तो यहाँ वो भी jurisdiction बढ़ गया है. वो आपने हमें वो असिस्टेंट रजिस्ट्रार के पास हमें दे दिए हैं. उसके पास होना चाहिए असिस्टेंट रजिस्ट्रार के पास, तो रहने दें उसके पास. वो बेशक बेहतर तयन कर लेगा. जो खुश नहीं होगा वो अपील में होगा. अब तो ये तो बल्कि ज्यादा उसको अहमियत दी जा रही है, रादर देन उसको निगेट कर रहे हैं. और राइट तो नहीं है 184(3) का. राइट आपके सारे महफूज हैं, जो आइन देता है, जो कानून देता है. ये नहीं कि आपने 184(3) की पिटीशन डिसमिस कर दी, 99 में आप नहीं जा सकते हैं, या आप सूट नहीं फाइल कर सकते हैं, जो भी चीज़. यहाँ तो लोग अजीब अजीब चीज़ें, जी मेरा इससे पैसे उधार हैं, वो जाके 184 डाल दिया उसने, हमने उसको डिसमिस कर दी. रजिस्ट्रार ने राइटली मेंटेनेबिलिटी भी किया, अपील है, हमने उसको डिसमिस कर दिया. इवन दो जस्ट वेस्टेड अननेसेसरी टाइम ऑफ अ जज ऑफ द एंटायर स्ट्रक्चर ऑफ द सुप्रीम कोर्ट. So I don't know what are we taking away? Back to the same question, what are we taking away?
इसमें इस वक्त क्या सिस्टम चल रहा है? 184(3) में सिस्टम क्या चल रहा है?
2 सिस्टम्स हैं. एक है कि जब कोई पिटीशन आती है, जब कोई पिटीशन फाइल होती है तो वो ऑफिस के इससे होके जाती है. रजिस्ट्रार ऑफिस वुड फर्स्ट एग्जामिन वेदर इट मीट्स द थ्रेशोल्ड और नॉट. इनफैक्ट उसके ऊपर जो ऑब्जेक्शंस आते हैं वो कहते हैं कि जी ये नहीं मीट करता, एंड दैट्स द एंड ऑफ द मैटर. यू फाइल अ चेंबर अपील. सो दैट इज वन राउट. द 184(3) का दूसरा है सो मोटो. नाउ this provision in the problems in the process on both counts. First, 184(3) की जो registrar ये power exercise कर रहा था, that power has now been given to this committee, the 3 senior most Chief Justice and 2 senior most judges.
You see, the power of registrar could be appealed in chamber, but in 3 members committee, where the appeal lies.
It is the 3 judges, my lord.
3 judges.
ये बात ठीक है कि उसमें ये बात हो सकती है कि जी उसकी कोई आपको जो है वो फिर आगे हेयरिंग नहीं होगी, हेयरिंग नहीं होगी. मगर
जी साहब आप ये बता देना कि अगर 2 जजेस या 3 जजेस बेंच चल रहा है, जैसे कि पुराना सिस्टम है, उसमें एक अगर 3 मेंबर्स समझते हैं कि दिस इज अ केस ऑफ पब्लिक इंपॉर्टेंस, वो रेफर करते हैं ऑनरेबल चीफ जस्टिस को, और चीफ जस्टिस इनकार कर जाता कि तीनों से एग्री नहीं करता. He has all the power, more power. 3 judges sitting in the court. The chief justice alone, sitting in a chamber, can undo this.
And the suo motu particularly, उसमें तो और ज़्यादा फिर problematic है. Because उसमें तो खुद ही कर रहे हैं, वो खुद ही examine कर रहे हैं.
3 में भी the process is that if the committee thinks that it's a matter of 184(3), they'll mark it to a bench which is not less than 3. If they think it's not, they'll send it to a 2-member bench maybe, or whatever. It's not throwing out the list.
And my lord, as my lord the Chief Justice has just observed, it is not that other than 184(3), the constitution of this country or the laws of this country do not provide any remedy.
May I add to this?
My lord.
All that the committee will be doing, raising an objection.
Yes.
Objection to the effect, and that is for us internally to provide an appeal against
My lords
that
can
order.
suitably amend the rules
You
and
see,
perhaps
again,
provide an appeal.
the question is that since 1980 had not amended our rules, that is why the Parliament was forced to amend them. Had we amended them ourselves, because the bars were raising questions, the public was raising questions, the litigants were raising questions, we actually forced the Parliament to do it for us. And everyone, there's consensus that this is exactly, अब इस वक्त हम सिर्फ ये कह रहे हैं कि बहुत अच्छा काम है, पार्लियामेंट ना करती आप कर लेते. But what when we are refusing to do that? And that is exactly what has happened.
Being 43
I think
years.
this act simply says that we've not been doing our job earlier.
That is it.
And it's saying we'll do it for you because you've been sleeping all the time.
You were too polite to say that.
My lord, we have section 4.
I've read that. Actually.
Section 5.
अभी तक जवाब नहीं आया.
जी, वो आपने जो बात कही कि जी अब फुल कोर्ट अगर बैठेगी, उसमें उस राइट ऑफ अपील का क्या होगा?
पहले क्वेश्चन तो ये है कि राइट ऑफ अपील कॉन्स्टिट्यूशनल अमेंडमेंट के बगैर कैसे आ सकती है जब 184(3) is a constitutional provision and it specifically it does not provide a right of appeal. Where the right of appeal was sought to be provided, it was provided specifically in the constitution. So aren't you adding to the constitution or amending the constitution without an amended
Mr.
amendment
Attorney
in the
General, entry
constitution?
55 says that we'll confer, enhance your jurisdiction. तो उन्होंने एक और 84 की अपील बना दी है. तो
Well,
enhance
फिर
नहीं होगी
185 की भी फिर एक और अपील बन सकती है.
बना दें.
बन सकती है.
बना सकते
सेकंड अपील तो है, हमें वैसे भी बताया हुआ हमने कि हम
Speaking
दे
for
सकते हैं.
myself, Learned Attorney General,
Parliament.
Learned Attorney
Why
General,
not a
speaking
third
for
appeal?
myself.
Why not then a third appeal or a fourth
Now
appeal
then.
or a fifth appeal?
Learned-
तब आएगी तो
It's the Parliament won't do absurd things, and
No,
of
it's not
course,
a question of, no, it's
you
not
know,
a question of absurdity because this undercuts the review, the whole concept of review. The finality of judgments for res judicata is regarded as one of the most fundamental principles of the administration of justice.
it surely does.
Exception, no, अगर आप बात कर रहे हैं तो ये तो फिर infinity हो गया.
But, infinity नहीं है,
Parliament
obviously, you know,
देखिए,
we're talking about the
principle
Parliament
की-
here,
देखिए,
we're
Mr.
not
Attorney
talking
General,
about.
आप बात फिर आ जाती है कंजेक्चर और थ्योरी और ये और वो बात प्रिंसिपल की हो रही है, असूल समझने की है ना. एक दफा एक बात को कंसीड कर दिया जाए, एक्सेप्ट कर लिया जाए, in principle then there is no limit. And therefore, if there is no limit, the question to my mind arises that therefore the power does not exist.
Lord,
This is the
great
point.
respect. I would
लेकिन रिव्यू
disagree.
जुरिस्डिक्शन भी है ना. रिव्यू जुरिस्डिक्शन का क्या कॉन्सेप्ट है कि सुप्रीम कोर्ट में फाइनलिटी हो गई, अब आप मैक्सिमम में रिव्यू कर रहे हैं. वो हमने
You know, with great respect, when it comes to
ये देखें ना, ये जरा
even on this plane, even on this
आसान
plane,
बात
and
नहीं है.
even on this plane, and I submit that entry 55 sufficiently covers section 5.
Can we
even-
go to the next point?
Ji.
I'll only add to this, Learned Attorney General, there's a distinction. Article 185 explicitly is for those judgments that are rendered by the lower courts. Here the appeal has been provided.
184.
in 184.3, which is our original jurisdiction. And it's only of a supplemental nature. It's a continuation of the same proceedings, the original jurisdiction.
And,
so see how
and in a context where this court becomes the first and the final court in the same proceedings.
That's
Where-
done. Are you done?
My Lord, to this extent, and I'm just going to conclude my other two submissions. And I have placed on with my
will
paper book
certainly
the
look at
judgments
it,
of
don't worry.
in Baz Mohammad Kakad case and the Punjab Provincial Cooperatives case. They are in volume 2, my Lord. My Lord, section 6 now, right to...
There was one concern also expressed by Justice Aisha
Ji, wo main
Malik,
address
which
karna
was that
Sorry.
if we follow this procedure, then when the full court meets, then the appeal goes away. एक ये भी point था, इसको आप कैसे address करेंगे? Because I mean, one answer could be कि if the wisdom of all is such है, तो फिर वो naturally सब लोगों ने सारे एंगल देखे होंगे, एड्रेस करना चाहते हैं.
उसमें एक ये बात है, मैंने अपने रिटन सबमिशंस में ये कहा है कि आप इसको टू दैट एक्सटेंट रीड डाउन कर लेंगे.
इस हद तक रीड डाउन करें.
जहाँ पे फुल कोर्ट होगी नेचुरली अपील
Yeah, 4 or 5 को harmonize अगर कर
बट
लें,
आप उसको ये कर सकते हैं. सॉरी सर, जस्ट
I'm just saying, if you harmonize 4 and 5 in a situation where the whole full court is hearing it, the question of appeal does not arise.
माय लॉर्ड,
That's
ये अब
quite
15
simple.
बैठे हुए, सो मैं जैसे so if it was in original proceedings it was a bench comprising of 7 lordships on this side, the appeal would have come before the remainder 8 judges, because it had to be a bench larger than the bench hearing the original appeal. In this case we are before your lordships in original jurisdiction, full court.
आप देखिए ना, इसमें ये जरूरी नहीं है कि one jumps from 5 member to full court. अभी 15 जज हैं, ठीक है ना. फर्ज करें एक आर्टिकल 184(3) की जजमेंट वो पिटीशन आ जाती है, 9 member बेंच बन जाता है. फुल कोर्ट तो नहीं है.
My lord would be mindful of
बात
this.
सुन
Committee
अब ये
would be
हो
mindful
सकता है,
of this.
हो सकता है आप कहते हैं यहाँ पे जी वो चीफ जस्टिस मास्टर ऑफ द रोस्टर है, तो ये खराब और वो खराब और ये खराब. फर्ज करें 3 member कमेटी कहती है जी हम भी उसमें बैठ सकते हैं, हम राइट ऑफ अपील खत्म कर देते हैं, हम 9 member बेंच बना देते हैं.
Lord,
आप देखिए ना, आप इसको एड्रेस कीजिए ना. ये ऐसी बात नहीं है कि जी द विजडम ऑफ द फुल कोर्ट आ गई तो राइट ऑफ अपील तो खत्म हो गया. आप ये
मैं
इस तरह की
what
बात
I'm
ना करें.
what I'm submitting is that now it's a duty. ड्यूटी कास्ट हो गई है इस कमेटी के ऊपर.
अपील
But उसी तरह ड्यूटी पहले चीफ जस्टिस पर भी थी ना. नाउ यू पुटिंग द ड्यूटी ऑन द फुल
और ये
कोर्ट,
तो नहीं हो
तो
सकता.
कोर्ट
It's
तो
a
फिर
vested
अपनी
right.
मर्जी पर ही चल रही है ना. व्हेनेवर इट वांट्स टू डू समथिंग वो राइट ब्लॉक करना चाहेगी. What you are saying is that substantive right that you have created under the statute is again left to the mercy of the court. It will decide कि ये substantive right देनी है कि नहीं. तो फिर आपने ये right दी किस मकसद के लिए दी?
8 member बेंच बन जाए, 9 member बेंच
So,
बन जाए, राइट ऑफ अपील खत्म हो गया.
so let me just
I think what we can do is,
writing, my lord.
we can logically interpret the legislation. Now, for instance, when this case was first heard, it was an 8-member bench. There were not enough judges, still aren't, to have heard an appeal, theoretically speaking.
Yes.
So, unless the bench, the very first day it sat, it decided to strike out this law, that's a different thing. But if it was sustainable, then how could an 8-member bench be constituted to begin with? Because that right of appeal was taken away from day one the bench sat. We are now worried about the right of appeal when there is a full court, but this question should have been raised against those, or when the bench was being constituted, that the law provides for a right of appeal. Here we are 8 of them. There aren't 9 of us available. So how that right of appeal has already gone away. We have decided an important component of the law. Before sitting in the courtroom, we have decided it. Is that correct?
Yes.
So when we are concerned now, we should have been concerned earlier too. So वो तो गई.
एक्चुअली जब वो CMAs थी फुल कोर्ट के लिए, जब आर्ग्यू हो रही थी, तो उस वक्त ये सवाल बकायदा उठाया गया कि आप कह रहे हैं फुल कोर्ट बनाई जाए, आपको तो कहना ही नहीं चाहिए कि फुल कोर्ट बनाई जाए, आपको तो कहना चाहिए दिस मैटर शुड बी हर्ड बाय लेसर नंबर. वो CMA की वो हेयरिंग पे नहीं गई, बट
But the burden
And
at the end of the day was on us.
The
Since
question was in fact put by me.
My Lord,
And so therefore it's not that the question was not there. It
My
was-
Lord, if I may briefly respond to it, followed by a response in writing.
Let me add to this. Let me add. मेरे ख्याल से जो मैं गदर कर चुका हूँ और ऑर्डरशीट पढ़ने के बाद महसूस हो रहा है कि जब ये पिटीशन ली गई उस वक्त तो यकीनन बिल था, इट वाज नॉट थ्रू द पार्लियामेंट, एक्ट नहीं बना था, बनने से पहले सस्पेंड होता जो कि आज तक इनफील्ड नहीं है। अगर ये इनफील्ड होता तो शायद 8 मेंबर बेंच उस वक्त भी ना बनता। इसका मतलब ये कि हम एक्ट को मान रहे हैं, अगर हम बेंच पे एतराज़ कर रहे हैं इसका मतलब हम एक्ट को मान रहे हैं, और अगर एक्ट सस्पेंड है फिर तो अगर 8 मेंबर बन सकते व्हाई नॉट फुल कोर्ट।
So, मैं इसका brief एक response दूँ and then followed by a detailed response in writing, briefly put, and that would perhaps address ladyship's question as well, but in subject to what we have to submit in writing. Going forward, if this act is upheld and is declared intra vires, the committee at all times would be mindful that there is a right of appeal, a substantive right, which will get obliterated if a bench beyond a certain number, given the numerical strength of the court at a particular time, is constituted. So therefore, that power, that administrative power exercised by the bench,
मिस्टर अटॉर्नी जनरल, इसका मतलब है पार्लियामेंट ने फैसला कर लिया कि जी फुल कोर्ट, सुप्रीम कोर्ट की फुल कोर्ट कभी बैठ ही नहीं सकती।
in cases, in circumstances हो सकता है, जैसे अभी भी है।
repercussions तो सोचिए आपकी बात की कि यही प्रिसाइसली सवाल है कि इस लॉ की इस सेक्शन की वजह से
So let me put it differently.
ये
Now,
फुल कोर्ट कभी बैठ ही नहीं सकती।
नहीं, full court आप बैठेंगे।
In Article
in
184,
exceptional
three
matters,
questions which are the most important question that can ever be raised before the court.
in exceptional circumstances, it
General,
might be so.
Mr.
But
Attorney
does that,
General,
is that to just take away the right of appeal?
Attorney General, the other way to look at it is that if the committee were to have the view that the matter is so grave and so serious that a larger bench which will not provide for an appeal be made, either full court or any large bench, then that be so. I mean, that is how the committee will decide, looking at the issue. So it doesn't take away the power to constitute a larger bench or a full court, but at the same time, it will be saying that it's so important that a collective wisdom will prevail. There is no, I mean, doesn't really, it can be easily
It can be reconciled.
It can
My
be
Lord,
read
Section
down.
6, right to appoint.
Section 5 can be read down.
My Lord, to that extent, my Lords can hold that in exceptional cases and when a situation this sort arises, that be so, my Lord.
Right of appeal पे substantive right नहीं है, जो statute.
Ladyship, look, we are faced with a situation here, and let me just be very candid now. We have had recording, we have had car case, and we have God knows what not. And all of that has happened under 184.3. With great respect. With great respect. And steel mill is a classic example. Steel mill was in profits at the time when all of that happened, as far as my information goes. It had 12 billion worth of raw material lying there. And now we are faced with an asset which is constantly
How
bleeding
many of
us.
those were full court? How many of those were full court judgments?
My Lord, may not be.
यही तो
Not be. मैं ये कह रहा हूँ कि इसको reconcile किया जा सकता है.
साहब यही तो पॉइंट है कि एक तरफ आप कह रहे हैं हम राइट ऑफ अपील दे रहे हैं इन ऑर्डर टू एड्रेस प्रिसाइसली दीस काइंड ऑफ थिंग्स, दूसरी तरफ कह रहे हैं कि चलो फुल कोर्ट बन जाए तो बन जाए,
फुल कोर्ट बन जाए, मैं ये कह रहा हूँ कि there might be issues in time.
आप काइंडली जरा थोड़ी सी
नहीं, मैं there might be issues in time. आप
applications of your submission तो काइंड
उसको ये इस तरह से आपको कर देता हूँ कि आप ये balance आप रख
Attorney
लेंगे.
General Saab, we are all grown ups, right?
Attorney General Saab,
Can I just, the problem arose, I think thousands of articles have been written, lawyers have spoken about it. We keep talking about the two chariots, but let's place some emphasis on the lawyers also say. There has been allegations, and I can deny it, but it doesn't. Public opinion thinks that 184.3 has been misused, jurisdiction has been exceeded. ठीक है? So what you are saying is, first of all, we did not create the mess. You created the mess. We are trying to solve your mess. What did we do? 3-member bench judgment, 184.3, final judgment. Nothing can be done. Now we about full courts only. What about the 3-member bench judgment? It was a 3-member bench judgment which did Recordic. It was not a full court or even a large bench. A 3-member bench is the normal, smallest bench in the Supreme Court. So what could you do? Nothing. Now you come in advisory jurisdiction. We have to kind of find ways and means because it's the interest of the country at stake. I would rather surrender my high status and at the feet of the taxpayer public of Pakistan rather than give them a whopping liability of $6.5 billion because the independence of the judiciary. They'll say, what are you talking about? Independence of judiciary? Independence of Pakistan will disappear if you labor this much of debt on Pakistan, 6.5 billion. It's not easy. We don't understand the repercussion of things. Fine. I'm not saying that judges who decided that they did what they thought time, how they were assisted according to their conscience correctly in their minds. Yes, but we make mistakes. Suppose I was a member of this bench. I would love this thing if it came to my mind, repercussions. Okay, now there's a right of appeal. I can undo. Review jurisdiction, you know what the review jurisdiction is. Take the case of Zulfikar Ali Bhutto.
Yes.
Supreme Court split. Review, unanimous. Because the scope of review is very different creature. It is error floating on the record, so they didn't even go there. That could not be rectified through review. You had to create 184.3. If आपको simple बोलना चाहिए, अगर आप अपने इतने ज़्यादा काम ना करें, थोड़े हदूद में रहें, शायद हमें इस legislation की भी ज़रूरत नहीं पड़ती. हमने भी तो थोड़ी गलतियां कर ली. हमें देखिए हमारा problem ये हो गया ना, अनबड़ी बन गई है और तकब्बुर. हमसे गलतियां हुई हैं, मुझसे गलतियां हुई हैं. मान लें गलतियां हुई हैं, ठीक है, हमने ऐसी चीजें की हैं, हमने जस्टिफाई किए मिलिट्री टेक ओवर्स को, मान ले गलती की है, ठीक है. अदरवाइज आइन की कोई हैसियत नहीं है. अगर जजमेंट लॉ हम उसको रख लेंगे अपने ऊपर तो वो तो फिर आइन तो गया, फिर वो तो सारे जजेस थे, उन्होंने सबने एंडोर्स कर दिया. मैं नहीं मानूंगा इसको क्योंकि मैंने हल्फ नहीं उठाया है. द मिनट आई से दैट प्लीज फाइल अ against me that I'm violating my oath of office if I say even this, कि I will endorse these subsequent acts. तो हमें मुल्क का भी तो सोचना चाहिए. हमें अपनी सिर्फ अपनी अना और आपको अना और इन ख्वाजा साहब मुझे नहीं पता उनको क्या मसला हो रहा है, उनको हमारा फिगर पढ़िए. हम स्यूमोटो हर जगह करते हैं, हमने यहाँ क्यों नहीं स्यूमोटो किया? 10 पिटिशंस आ गई, पब्लिक में से तो कोई नहीं आ रहा है. पता क्या मसला है लोगों का? उनके तो कोई मसले नहीं हो, कहते हैं भाई हमारा केस चला के. Sorry, I'm diverging, but we have to see the larger picture also. We have to see work within the constitution where every citizen gets his due. What are we doing? What are we taking away from him? Focus on that.
Nothing, my lord. And section 6, my lord.
इसमें Attorney General साहब law reforms ordinance के तहत there's a right of appeal. लेकिन कई cases में depending on the issues, the high courts constitute larger benches and therefore that right of appeal is not available. लेकिन जहाँ तक देखें ना, जो अभी बात हुई है 184.3 is discretionary. Now, यहाँ पे जितनी बात हुई है, even the petitioners, their counsels, they all agree that this law is in the interest of the litigants. It actually enhances access to justice. So why shouldn't we just not exercise our jurisdiction? Because in exercising jurisdiction, we will be going against the interests of the litigants. Why should we go against the rights of the litigants? It is in their interest and in their favor.
एक प्रॉब्लम अभी जो अपील के बारे में बात हो रही है, कॉन्स्टिट्यूशन हैज आंसर टू इट. सपोज आज हम 15 बैठे हैं, कल 2 वैकेंसीज हैं, वो भी फिलअप होती है, 17 के 17 बैठते हैं. इशू यहाँ पे ये कि अपील की रेमेडी नहीं हो, इस एक्ट के तहत अवेलेबल नहीं हो. लेकिन कॉन्स्टिट्यूशन कहता है आर्टिकल 181 में, जब ऐसी सिचुएशन आ जाए तो a judge from the High Court can be asked to act temporarily judge of the Supreme Court. तो वो आपका एक्ट कहता है कि larger bench will hear the appeal. So add one judge. This is larger bench. Appeal is there. No problem. I think problem is solved by the Constitution.
The remaining judges would be the same.
Yes, of course.
फैसला तो वही आएगा.
This was just
All
like
judges from
like
Nawa-i-Waqt Group.
like review.
आपने conclude कर लिए.
My lord, I just now the section, as far as section 7 is concerned, I've already submitted. I think this provision surely addresses the concerns of the litigants, fixation of cases under
The
section
provision
7.
of intra-court appeal,
ये जो
that is to be seen.
आपने-
Intra-court appeal जो आपकी है, उसको देखना है.
इधर सिर्फ प्रॉब्लम ये जो आपने रिट्रोस्पेक्टिविटी दी है इस लॉ को, उससे हमारी पेंडेंसी और ज्यादा नहीं हो जाएगी.
My lord, at one end, now my lord would have
देखिए
to see
हम
how...
सारी बात ठीक है मान लेते हैं जी, आप इंटरेस्ट कर रहे हैं उधर आप उसको रिट्रोस्पेक्टिव, अब आप सोचिए 185(3) का और आप इस तारीख से दे रहे हैं, यू गोइंग बैक अप, व्हाट डू यू एक्सपेक्ट अस टू डू देन? वी द होल विल बी गटेड.
How many cases would there be, my lord?
And no limitation period is
ये
here.
तो आप ना करें ना.
My lord,
ये थोड़ा
I
सा
think what has been
थोड़ा सा
what
उधर ख्याल रखा करें ना. आप रखिए, आप लाएं
what the parliament has,
चलो ठीक
my
है.
lord, what the parliament has tried to address here is
So you see, it
the
is very
same
open-ended.
principle.
Prior to the commencement of this act, so it will go to 1947 or
47
what?
जितने 185 73 से शुरू हो जाएंगे.
My lord, 1947 तो नहीं, 75 में पहला हुआ था.
एक बात है, अब आप इसमें
88
is
में आ गया
open-ended
था
ना.
दूसरा, and then
You have fixed a limitation of 30
subsection
days
2 of
for
section
filing
5.
appeal prior to commencement of this act, means all previous decisions, all persons can come to this court within 30 days after the sustaining the.
I think 30 days have expired. I don't know how many came
ये
actually.
बताइए अटॉर्नी जनरल साहब,
जरा ये मालूम करें दफ्तर से कि इस इनैक्टमेंट के बाद
law was
अपील कितनी फाइल हुई है इस प्रोविजन के तहत?
वैसे नहीं हुई होगी because the law was
सस्पेंडेड.
Leonard-
ओके ओके, I see.
Leonard
couldn't have
Attorney
taken
तो
effect.
फिर एक और
Leonard
वो एक और
Attorney
छूट जाएगा ना.
ये बताइए कितनी दफा इस कोर्ट ने मार्शल लॉज को और डिक्टेटर्स को वैलिडेट किया है? कैन द पीपल ऑफ दिस कंट्री फाइल अपील्स एंड
Review.
have those judgments annulled? Why not?
I would hope so.
I think this is our accountability. Let us be open about it. Why
And
do we
my lord,
fear
just
if
to-
it's
Quick
Otherwise,
history,
we'll
I
be brushing
think-
things under the mat.
1975, Manzoor Alai was the first case under 183, and thereafter, after 13 years, it was Benazir Bhutto case, 1988. ज़्यादा जो jurisdiction exercise हुई है वो perhaps
But where
पिछले
do you
15
draw the
साल में
line?
हुई है.
Where do you draw the line? I mean, the question is, if there is transparency, then let it be. I mean,
it
why
be.
brush something under the mat and look into some? Why?
My lord,
Let's undo Federal Shariat Court Maulvi Tamizuddin Khan case. Effectively, it won't mean anything, but maybe it will look good. I don't know. Because he's dead or whatever, long past. Go on.
my lord, I would conclude my submissions with this. I have the written submissions along with reliances. I have noted down one question जिसका detail में
ये
हमने
सेक्शन
submission
6
करना
पे
है,
भी
वो-
बता दीजिए लर्नेड अटॉर्नी जनरल,
My
ये
lord.
जो आपका
Right to counsel.
Yes, because it
Now-
is already covered under Article 188 of the Constitution,
उसमें order 26 है.
power of the review.
जी, order
So you
26.
have said that the party shall have the right to counsel of its own choice.
पहले जरा
Counsel.
my lord का 188 पढ़ लें जो refer कर रहे हैं my lord.
188 is the Supreme Court shall
हाँ पढ़ लें जरा.
have power subject to the provisions of any act of parliament and of any rules made by the Supreme Court to review any judgment pronounced or any order made by it.
Yes.
So this power under the power of review.
Council का
Change of
provision rules
counsel.
में डाला गया है ना.
The order 26, rule 6.
अच्छा.
Order 26 deals with the review, the Supreme Court rules. And
is there-
rule 6 is the
is
rule
there
where the
No,
court.
I am only asking about the change of counsel, why this provision has been created, because the new counsel will come and he will argue the whole case as an appeal, because you know the scope of the review. Normally, the counsel who appeared originally, he came in review and we hear him. New counsel will come with new fees and with new motivation and new energy. Then he will try to argue the whole case again as an appellate jurisdiction.
And actually, the wisdom.
एक second, I think my lord has made a very valid point. If I was to sit in a court, first question I would say, yes, where did you take this point in your pleadings? And if he hasn't, he hasn't.
Hasn't.
I mean, my
And if-
answer
if
to
there are
him
no
would
written
be, he
submissions
can't,
filed, then
arguing
he
is like arguing, but we will go by the written, you didn't take this point, खत्म जाओ भाई.
Yes.
वो review में वो appeal का power नहीं हो जाएगा उसके पास.
Review नहीं
तो
grounds.
उसकी विजडम यही थी ना कि काउंसिल The same bench, same counsel.
Same
They would know what
settings,
transpired last time in the hearing, what questions he had agitated.
अपनी भी wisdom
My
Give me
lord,
wisdom.
ab jaise, for example, I am assuming that the proceedings of this courtroom are transcribed and they are, we have the transcripts desired or required. Technology can be used, but that said, if there are submissions and obviously people file their concise statements or they bring their petitions, file their responses or make written submissions, nobody can go beyond that. Now, if a counsel, the new counsel comes before your lordships and make a point which is beyond the pleadings before your lordship or any written
What is the
submission
purpose
filed,
of introducing this section? Why new counsel? We totally
lawyers demand. मेरे ख्याल में lawyers demand थी.
My lord, ये वो वाली बात है जो मैं
अभी
वो
वही
कर
सवाल
लेता हूँ
आएगा
कि
तो what is the fundamental right which is
lawyers का demand था या किसका litigants का demand था?
philosophy क्या है इसके पीछे नए वकील को लाने की?
My lord, न्यूयॉर्क बार का जो इम्तिहान होता है तो उसमें कोई 35% हर साल में 2 दफा होता है तो फेल हो जाता है. जो हमारा यहाँ पे जो सिस्टम चला आ रहा है उसमें there is a lot of issues, so मैं मजीद नहीं कहता. बता दिया आपको.
Mr. AG, AG sir, towards right. 188 says subject to Act of Majlis Shura. Whether any act has been promulgated to regulate this article prior to this act. Is there any act?
My lord, there was an act, review of judgments in order to not, well, this particular provision actually was also included in that act and a 3-member bench struck that law.
It was subsequent to this law. It was not prior to this
Yeah,
act.
subsequent to this,
Prior
but
to
it came decided before.
There was no act.
Ji?
There was no act.
No.
So the things were going on unconstitutionally.
Under Order 26.
Unconstitutionally because the Constitution says to
Act and the rules. And the rules.
Both, not,
So there
not
was
or.
Order 26.
There is no
which-
or, there is and.
And.
So both must be there, act and the rules. So where is the act?
My lord,
Again.
here you would read it interchangeably perhaps, but in order to protect Order 26
Protect the
under the
Constitution
Supreme Court
so
rules, and it was being regulated.
Okay,
under the
one
Supreme Court
question
rules.
I have of a general importance. When I'm sitting in a court of law, am I bound by the Supreme Court rules? Or rules are an aid of administration of justice, and rules bind the counsel and the litigants but does not bind the court? What is your position on that? Am I bound to follow the rules of 1980? I mean, like for instance, Order 33 says I can condone delay, I can do various things. So it is there to be followed by litigants and counsel, but there may be cases of extreme injustice. We may overlook, for instance, in criminal matters, we rarely even ever dismiss things on grounds of limitation, though it is provided that it has to be filed within a certain period of time, because the liberties of the subject, we haven't given a decision on it. So, but I think rules are really to show us, guide us, not really to bind us.
Actually, rules acknowledge this. Order 33, Rule 6 actually says so.
वो एक overall है.
Gee, it says that rules shall, nothing in these rules shall be deemed to limit or otherwise affect the
At
inherent
the
powers
end
of
of
the
the day,
court.
it's not so important,
It's practice and
significant
procedure,
document.
my lord. It is practice and procedure. These are all.
और वो भी हमने
procedural
order
in nature.
47 को connect कर दिया and civil proceedings, civil procedures court के साथ. So these are not, I mean, these are not like ironclad things that we cannot, we'll see where the justice of the cause lies, and of course, it doesn't mean they're totally irrelevant, so we will see when it's appropriate. It may be a case, it may be a bad case, I don't know. So आपका you conclude या कुछ और रह गया
My
आपका?
lord, I have
But
concluded.
Attorney General, if I
In
may ask a
writing,
question,
I mean,
if I may ask a question.
Well,
If you are not bound by the Supreme Court rules in terms of whatever the Supreme Court rules say, but we are bound by Act of Parliament in regard to our own practice and procedure, do you think that is a constitutionally viable position?
My lord,
Then if the rules are made by the full court on the administrative side, and any particular bench can say, well, goodbye to the rules, why shouldn't that bench have the right to say goodbye to the act?
my lord, my response to that would be that both the preamble, from which we draw those salient features.
No, I think the thing is
The
that when
independence
the
of-
Supreme Court is sitting as a court of law, what is it bound by? If it's not even bound by its own rules, Why should we be bound by Act of Parliament?
My lord, the
We can
rules,
say then
the
maybe,
rules, the
then
rules
maybe
say.
that particular bench can say, well, we don't recognize section, what is it, section 6. And another bench can say, well, we recognize section 6.
My lord,
I mean, why should not your, this law that you're defending,
I think the
not
rule,
that be put in the same category vis-a-vis our own rules? If we are not bound by one, why should we be bound by the other?
As I view it, I think priority number 1 is constitution. Number 2 in scale of importance is law. Number 3 is rules. Then come regulations, then come notifications, then come whatever you want to, instructions. So this is, in my mind, I go by that approach. I may be wrong.
my lord, the rules, actually Rule 6 of Order 33 itself acknowledges that.
I think the Constitution actually
abuse of process नहीं होगी and of justice को meet करने के लिए you're not.
Attorney General, the rules actually come out of the Constitution, and Constitution says the court has to be regulated. So I think that, in my opinion, certainly the rules regulate the affairs and we bound by them. And they might be in the trajectory starting with the Constitution, law and the rules, but all of them are binding, and that's how the system works.
And my lords would also acknowledge that this is not a case where Article 199 per se has been challenged on of it being violative of salient features for that matter. Of course, even if that was so, both 191 and the preamble from which the salient features flow were enacted at the same time. It is not a subsequent amendment where relying upon Kesavananda Bharti or DBA Rawalpindi matter could have proceeded. So when the preamble, when the Constitution was being made, 199 has not undergone any amendment ever since. So therefore, my lords, my respectful submission would be that this act, my lord, be declared constitutional and the petitions be rejected to that effect. And nothing in this act in any way undermines the independence of judiciary nor has any externality been introduced where any other organ of the state or branch of government has been given any role whatsoever.
Hopefully these are your final words. Hopefully.
I'm going to
Attorney General sir.
My lord.
आपने कंक्लूड तो कर लिया, बस एक क्वेश्चन पूछना था कि अगर फर्ज करिए कभी इसको हम अल्ट्रावायलेट डिक्लेयर कर देते तो बात ख़त्म हो, लेकिन अगर इसको हम कहते हैं कि वैलिड लॉ है, वैलिड लॉ हो जाएगा वहाँ जब ये बना था। इन बिटवीन जो फैसले हुए हैं, व्हाट इज द फेट ऑफ दोज डिसीजंस?
My lord,
अगर वैलिड करते हैं तो फ्रॉम दैट डेट होगा, तो फिर क्या होगा? इसके बारे में आप बता दें।
They become past and closed transactions in several instances in the past where a similar situation or a situation arisen where a legal position had changed, but cases were decided or transactions had happened. The courts protected those under past and closed transactions. So that would be the effective matter which stood decided.
Can the committee not retrospectively, suppose if the law is sustained, can the committee not retrospectively grant permission? The bench was constituted,
my lord,
assumed as if by consent. Let's put it like that. I don't know if that's possible or not.
Stand aside.
As if by consent. Let's put it like that. I don't know if that's possible
Cases
or
which
not.
stand decided, they stand decided.
अगर हम ये भी कर लें कि अगर कोई बहुत ही ऐसा unusual case आ जाए, I don't know.
My lord, I don't know where the line would be drawn, but in so far as
I think
जी मैं इसको भी एड्रेस कर दूंगा।
ड्यूरिंग द पीरियड की बात हो रही है ना,
जो केसेस
इस दौरान जो हुए फैसले हो गए, उनका क्या बनेगा?
सो जो केसेस लिस्ट अब पेंडिंग ही नहीं है और वो डिसाइड हो गए हैं केसेस
During this period.
जी पीरियड, उसको अब आपको देखना होगा कि उसको आप पास्ट एंड क्लोज में प्रोटेक्ट करते हैं जो फैसले हो गए।
इतना पास्ट नहीं हुआ, अभी की बात है
वो। आई थिंक दैट इज समथिंग दैट माय लॉर्ड वुड हैव टू
दो चीजें हो
सी इफ माय लॉर्ड विश टू प्रोटेक्ट देम इन द पास्ट एंड
thinks of
क्लोज।
all the angles.
उसमें
This is
दो
possibility, that is possibility. So this is a possibility. We're just airing it. We don't know the answer.
उसमें दो चीजें हो सकती हैं, एक तो डिफेक्टो डॉक्ट्राइन को हम देख सकते हैं, दूसरा राइट ऑफ अपील हो जाएगी। So they can, जिनके
as far as 184.3 is concerned, उसकी होगी, जिनकी नहीं थी 184.3 वो तो सिर्फ बेंचेस की कॉन्स्टिट्यूशन तक रह जाएगी बात, उसमें आप देख सकते हैं कि वो तो
It won't be a classic, देखिए दो किस्म के होते हैं, एक होता है classic quorum non-judice, ठीक है, this won't fall in that category. It will be simply a procedural lapse, whether a procedural lapse will affect the outcome.
The cases which stand
I don't know, I mean, क्योंकि एक तो होता है ना सब्सटेंटिव राइट किसी की गई, बोले आपका क्या राइट किया,
वो डिसाइड हो गए केसेस, वो पास्ट एंड क्लोज।
नहीं, पास्ट एंड क्लोज का लफ्ज क्या अगर हम कहें, देखिए एक होती है यू सब्सटेंटिव राइट हैज बीन टेकन अवे, ओके दीस थ्री डिडंट हियर इट, दोस थ्री हर्ड इट, आपको क्या फर्क पड़ रहा है इससे? Are you with me? So I'm just thinking aloud.
Understood. So it does not, let's say, there's no, it's substantially कोई offend नहीं किया किसी right को, कोई, it was a matter of procedure.
और अगर कोई जैसे कहा कि कोई बहुत ही चीज हो गई ऐसे, वो रिव्यू तो पड़ा हुआ है फिर भी, और या अपील पड़ी हुई है 184 में, तो जी.
And in any event, I mean, it was a bench comprising of your lordship.
No, we don't want to kind of create a situation where things don't function. So भाई वो उसको क्या पड़ेगा? चलिए आपने मेरा अदालत में सुन लिया या सरदार साहब की अदालत में सुन लिया, कोर्ट तो थी ना, वो तो गलत quorum non-judice होता है ना, गलत अदालत अब चलेगा, इख्तियार ही नहीं था to begin with, हमारे पास इख्तियार तो था, बस सिर्फ वो एक practical procedural matter that would be really for us, not for the litigant, उसको क्या फर्क पड़ना है?
I would say, my lord, and that I think to that extent,
I don't think that it will affect the decided cases. It has become past and closed.
I think that's the only fair conclusion that we can arrive at, insofar as
we're just going to take a short break. Let Father Saab and others, and any other from the petitioner side. I see Mr. Bandari. You are for the petitioner or the?
Your lordships had put various political.
No, who are you for?
I am for PTI.
Which side of the divide?
I am supporting the petitioners, but I am also not saying that Article 191 is completely outs the powers of the Parliament.
I would really like to hear you. Anyone else from this side? Petitioner. तो अगर आप लोग articulate जरा कर लें, we'll take a short break.
My lord, I have actually filed my written submissions.
नहीं, अगर
मैं कर दूँगा.
Why are you depriving us the pleasure of hearing you? Unless you want to deprive us, that's fine.
No, not at all, my lord. I'm here.
चौधरी साहब भी हैं. तो and of course we won't rush it. आप अपने जवाब भी दे दीजिएगा जो आप देना चाहते हैं. And we'll just come after. Short, I think prayer time is also there. Short break, huh?
And if I may be granted leave, I have to.
As long as you leave somebody here who knows all the things, and then if required, submit the. If you think, if you want to, we can't force you to submit a reply. But it may be in your interest to do so.
Mr. Attorney General, best wishes from all of us on the assignment that is on. It's in the national interest, and it's very important for Pakistan. So our best wishes.
My lord,
I hope you are well prepared.
22 questions मुझसे पूछे हैं जी. You asked me.
आते हैं वापस आते हैं.
नहीं, 22 questions में you like me to ask you to answer now, or you want me to give me some time to.
नहीं, हम जरा वापस आ जाते हैं, फिर आपको कुछ सुनते हैं. अगर कोई बहुत ही पेचीदा सवाल हुआ फिर हम देखते हैं.
पेचीदा सवाल तो सारे ही हैं.
But देखिए, petitioner always comes prepared of all the questions कि ये सारे आ सकते हैं. तो वो देखें, other side can say that, but you are the petitioner.
May I say something?
जी.
That
देखिए, फाजिल साहब जरा बात समझने की कोशिश करें ना. The functioning of the Supreme Court has ground stand still. I don't want that to continue.
मुझे आप इजाजत दीजिए.
ठीक है.
मैं ये 22 सवाल जो हैं, मैं इनका जवाब लिख के आपको दे देता हूँ.
चलिए, आप हम वापस तो आ जाए, इनको तो सुनेंगे ना बंदारी साहब को. शायद आप मुतमईन हैं साहब को तो मैं ये ऐसी जबरदस्त बात करें आप.
बंदारी साहब को जो है मेरे पास आ चुका है जी. मुझे आप इतनी दीजिए.
देते हैं, वापस आके देते हैं. देखते हैं, सुने तो कुछ थोड़ी बात.
देखना तो ये है ना कि पार्टीज क्या कहती हैं, वो पार्लियामेंट की सुपरमेसी चाहती हैं या नहीं चाहती.
सुनकर मौके पे हमने नहीं सुना अभी तक. थैंक यू. यू कैन गो देन लीव समवन हियर कॉम्पिटेंट. हाँ, थैंक यू.
ओके, थैंक यू.
15-20 मिनट.
15 मिनट.
की